Yes.
Thank you. May lawyer Hand please answer the state's questions?
Thank you, Your Honor. Sir, can you please state your name and date of birth?
Nicholas Michael, phone 62994.
And sir, what are the last 4 digits of your social security number?
5214.
Have you ever been known by any of their names or aliases?
No.
Where were you born?
New York.
How far did you go to school?
I graduated high school.
Can you read, write, and understand the English language?
Yes, sir.
Are you under the influence of any drugs or alcohol?
No.
Are you taking any medications?
No.
Are you suffering from any mental conditions or disorders?
No.
Do you understand why we're here today?
Yes, sir.
Sir, 21 CF 624, you've been charged in 1 count information with 1 count of possession of a controlled substance, a 3rd-degree felony, punished by up to 5 years in the Department of Corrections. To that charge, are you to plead guilty, not guilty, or no contest?
No contest.
Sir, do you understand that by entering this plea, you're waiving your right to a trial by jury?
Yes, sir.
Do you understand you are also waiving the following rights? Your right to have a jury determine your guilt or innocence, your right to see and hear the state's witnesses testify and have their lawyer question them, your right to subpoena, call your own witnesses to submit evidence on your behalf, your right to testify in your own defense or to remain silent, and your right to make the state prove the charges against you beyond a reasonable doubt. Do you understand, sir, that you're waiving all those rights by entering this plea today?
Yes, sir.
Counsel, reserve any matter for appeal?
No, we have not.
Mr. Buffon, do you understand you're given the right to appeal on all grounds except whether this court can impose this sentence?
Yes.
Sir, I have an opportunity to review your score sheet with your attorney.
Yes.
Holding it here in my hand, it shows you score a total sentence points of 33.2 with a lowest permissible prison sentence in months of 0. Sir, do you agree that this score sheet is accurate?
Yes, sir.
Sir, I have an opportunity to review a plea form while you've been in jail.
Yes.
I have an opportunity to sign that plea form.
Yes, sir.
Your signature tells me that you read and understood the rights listed on the plea form. Do you, in fact, read and understand the rights listed on the plea form?
Yes, sir.
Do you have any questions about the plea form at this time for your attorney?
No.
Other than what's contained in the plea form and what we just discussed on the record, has anyone promised you anything in exchange for this plea?
No.
Are you entering this plea of your own free will?
Yes.
Are you being forced or threatened by anyone?
No.
Are you pleading because given your options, you believe that this plea is in your own best interest?
Yes.
Are you satisfied with the advice and counsel of your attorney?
Yes, sir.
Has he done everything you've asked and answered all your questions?
Yes.
Have you had sufficient time to consider all your options?
Yes, sir.
Have you gone over all the discovery of this case with your attorney?
Yes.
Do you need any more time to speak with your attorney?
No.
So I'm aware of any physical evidence that can be tested for DNA to exonerate you. Do you understand, as a result of this plea, no physical evidence will be tested for DNA?
Yes.
Do you understand that if you're not a U.S. citizen, you may be subjected to removal or deportation as a result of this plea?
Yes, sir.
Do you understand that if you're deported as a result of this plea, of this case, it will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss this with your attorney?
No.
Sir, if the offense which you're pleading is a sexually violent offense or a sexually motivated offense, or if you've been previously convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent character upon completion of your sentence. Do you understand this warning, sir?
Yes.
Do you understand, sir, that you have a right to be physically present in the courtroom? Do you have any objection to your plea being conducted in this manner where you be broadcasted to the courtroom through video monitors? You have to answer law, sir.
What's up?
Do you have any objection to your plea being conducted in this manner where you be broadcasted to the courtroom through video monitors?
No.
Counsel, do you stipulate to a factual basis and advance for the purpose of the plea?
Yes.
United States Senate, please report.
Any other defense requests?
No, no.
Madam Clerk, anything? Based on the plea agreement, the plea colloquy, the plea of no contest, and related arrest affidavit facts, court accepts the plea agreement as agreed. Adjudication of guilt on the charge, 90 days Collier County Jail, credit 59 days served, 6-month driver license suspension per statute. Parties agreed to a business purpose or hardship license.
If you so qualify, yes, sir.
And the court will note and authorize that. Prosecution costs 100, public defender total charges 150, court costs 415, investigative 445. Any objection, request for hearing on any monetary amounts?
Do you want to hear those amounts, or do you accept them as they were in the paperwork that you're getting home?
Yeah, say it again?
Do you accept the cost of investigation that the sheriff's office reported in the discovery, or do you wish to have a full hearing where they testify to that number?
No, that's fine.
Okay, no need for it.
All monetary amounts to collections.
Yes, sir.
Anything else for the parties?
No, Judge.
Thank you for resolving your case. Everything approved. Thank you, Immokalee, for being available this afternoon. All right, Mr. Chandler, do you have any conflicting schedule where you need to address Mr. Casey sooner?
Yes, sir.
All right, let me just ask, we do have 2 plea agreements and then Mr. Casey, followed by the final case after that. How long do we anticipate Mr. Casey's case to be?
Maybe 15 more minutes.
All right.
Maybe not even that long.
Does the jail have any preference of the order?
No, not since we
All
got
right.
this one done.
Let's address Mr. Casey, that way Mr. Chandler can get on his way. And when we're ready, we'll have him appear. I mean,
He's present.
Oh, he's present. Okay, we'll
He's
have him come out then. All right, very well.
I just left this on so we can.
You've done fingerprinting. Awaiting Mr. Casey. Case number 16 CF 897. Mr. Chandler for the defense, Mr. Ashby for the state. All right, then Mr. Casey now present. Welcome back, Mr. Casey. Please be seated. Thank you. And Mr. Chandler, will this be a plea to the bench this afternoon?
Yes, sir.
All right, and you've gone over with Mr. Casey his rights to a full hearing,
Correct.
a plea agreement or plea to the bench with the distinctions of each.
Correct.
And Mr. Casey understands that on a plea to the bench, the state will not be bound by any offers and could request anything up to the maximum. And of course, the defense can make whatever request it wishes to make also.
Yes, sir.
And that's the way you wish to proceed, Mr. Casey?
Yes, sir.
All right, please raise your right hand and be sworn.
Swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Thank you. Before the plea colloquy, I believe I addressed this last time, but we did expedite at the defense request the competency evaluation, and Dr. Ewing was quite emphatic that Mr. Casey is competent, and I believe the parties agreed to the court making the finding of competency based on the report without the need for a hearing.
Yes, sir. Yes, sir.
So at this time, I have already, I think, but I will again find Mr. Casey competent to proceed with this bench plea. I will follow it up with a written order on the competency as to the plea colloquy.
Yes, sir. One matter of housekeeping, there is this case is a violent felony offender, special concern. That got that order. Council is going over right now. The state is going to be handing that out along with the score sheet for your honor before filling out of the fourth grade file.
Mr. Chandler, is that a disputed item?
Well, I wasn't aware they were going to be seeking to have him deemed a danger to the community, so.
So that is not agreed to, correct?
No, sir.
All right.
I'm not aware of that.
So you'll address that during the course of the hearing?
Yeah, I'm assuming the state will.
Right. And the defense will argue against it then?
Yes, sir.
All right.
So then we may need a full half hour because they wasn't anticipated. But in your honor state, based on nature of violation, the state is not in a position. The defendant is a violent felony special concern. The court does have to make a finding one way or the other. Have to possession order to make that finding.
Well, let's see how we go.
Okay, fair enough.
But that does not prevent, at this time, Mr. Chandler, the Mr. Casey from going forward to the bench, please, all right? Now, Mr. Chandler, if you prefer, I do have two quicker pleas. If you want to speak to Mr. Casey privately for just a few moments about this issue, and I can call you back.
Let's go ahead and go.
Well, I'm just saying I can call you back in 10 minutes if you wish, if you want to speak privately with him in attorney-client conference area.
I think.
Okay, very well. Statement inquired, Mr. Casey's been sworn.
Thank you, Your Honor. Sir, can you please state your name and date of birth?
My name is Timothy Justin Casey Senior,
And what's your date of birth?
6865,
What the last four digits of your social security number?
3808.
Have you ever been known by any of the major airways?
Yes, I have.
What are
One of them was, Elrod, and the other one was, and those are my nicknames, and, Silver Fox.
were you ever arrested on the program?
No,
Have you ever, where were you born?
I was born in Fort Lauderdale, Florida,
How far did you go to school?
in the 9th grade.
Can you read, write, and understand the English languages? Are you under the influence of any drug or alcohol?
No,
Are you taking any medication?
yes, I am.
Are you taking that medication as prescribed?
Yes.
I'm taking that medication today. Does that medication affect your ability to understand and perceive?
Absolutely not.
Are you suffering from any mental condition or disorder?
Yes,
Does that mental condition or disorder affect your ability to understand? Do you understand why we're here today?
yes, I do.
Sir, do you admit to being placed on probation in 16 CF 1897 for one count of aggravated battery with a deadly weapon,
Yes, I do.
a second degree felony punishable for 15 years of firearms correct? Do you admit to willfully and frankly violating probation by committing the following violations? Violation of condition 3 by changing the residence without first securing consent of the probation officer, and violation of condition 3 by leaving the county of residence without first securing consent of the probation officer. The initial willingness to stand to violate probation by committing those two violations.
I meant to, and I'm gonna admit, I wanna just say this, and I don't know if I should or if I could, but the change of address, legally, I didn't. The legal account, yes, I did. The only reason I'm saying that is because I'm really actually innocent of change of address. I'll speak out to law enforcement for that, my motel, pick my daughter, taking her back to take off. And that's why I picked up.
So, Mr. Casey, the question is, do you wish to admit for purposes of the plea to the bench, even though you may have had some
Even
defenses?
though I have, I do.
Very well.
Right. Sir, do you understand that the maximum sentence you can receive for the offense is 15 years of Department of Corrections?
Yes, sir.
Do you understand that by entering this admission, you were in the right to a hearing?
Yes, I am.
Do you understand you are also waiving the following rights? You are to have the court determine whether you committed the violation. You are to see and view the statement witnesses testify, have your word questioned. You are to subpoena, call your own witnesses to submit evidence on your behalf. You are to testify in your own defense, and you are to they prove the charges against you by the greater weight of the evidence. You understand, sir, that you waive all the right practices of the today. You also understand that after that hearing, the state will call you as a witness. And take one step back, sir. I understand that your intention today to enter an open plea to the court?
Yes.
Have your attorney made any promises or indications to you about what your sentence will be if you enter an open plea?
No.
You understand that if you enter an open plea, the only person about to stay in your sentence is the judge.
Yes, sir.
You understand that the maximum sentence is 15 years? You understand that the judge can choose to sentence you to the maximum sentence of 15 years? You understand all that you still enter an open plea today?
Yes, sir.
Counsel, have you observed any matters for appeal?
No.
Mr. Tate, do you understand that you're giving the right to appeal on all grounds except that this court can impose this sentence?
Yes, sir.
I'm holding your score sheet in my hand. It is 4 pages in length. I have an opportunity to review this form with the attorney.
Yes, sir, I will be substantial.
Very good. So do that.
Any issues with the score sheet from the defense side, Mr. Chandler?
Here's my other concern is they have this driving license suspended as an additional offense instead of a prior record. He wasn't on probation for the driving license suspended. I certainly understand he was on probation.
So you should be, you believe it should be in the category of prior record?
It is only around all of this.
Does it appear to have any substantial impact, Mr. Chandler?
It does not. It would impact it 0.2 points, which would take the total sentencing points from 116 to 115.8. So it would affect it a very minuscule amount, in all honesty.
I mean, obviously, we should be accurate depending on whatever is determined, but it should not affect substantially either side's argument.
No, sir, it wouldn't affect either.
What's
side.
the state's position as to how it should be classified?
Yeah, it doesn't appear that he was placed on probation for it. He was sentenced for a term of 5 years incarceration. It should be prior record.
So you agree with the defense?
Yeah.
All right, so it'll be redone then with that request from Mr. Chandler. All right, let's continue.
But it will only affect it 0.2 points. So.
Every little bit.
And you know, I can submit that. I just get a new.
That's fine. You can do a stipulated score sheet afterward.
That's fine.
Okay.
Correct. So, sir, I'm saying that one change when you change for score sheet 5.2. Do you agree the score sheet is accurate?
Yes, sir.
Sir, I'm going to review a admission form.
Yes, sir, I read through it. I'm ready to read
And then you're going to sign that admission form?
Yes.
You will sign it, yeah. Okay, so.
Sir, your signature tells that you're very honest with the right person on the admission form. You should practically understand the right person of the admission form. If you have any questions about the admission form, it is not your turn.
Yes, sir.
So I'm going to just discuss on the record that no promise is being exchanged with this admission. Are you making this admission of your own free will? Are you being forced a friend by anyone?
No.
Are you admitting to the violation because given your options, you believe that this admission is in your own best interest? Are you satisfied with life and counsel of your attorney? Have you done everything back and answered all the questions?
Yes, sir.
Have you gone over all the discovery in this case with your attorney? Have you had sufficient confidence in the offer to charge with whether what they said that they offer, voice your or enter an open plea with your attorney?
But we hadn't had a lot of time to work together in the issues that are being before the court today, but it's sufficient.
That you need more time to speak with your attorney? Do You understand that you're not a U.S. citizen, may be subjected to removal or deportation as a result. Yes. You understand that if you're deported as a result of this case, you will not be a basis for withdrawal of admission. You need any additional time to discuss this with your attorney. No. Sir, this offense is a sexually violent offense or a sexually motivated offense, or if you prove convicted of such an offense, this admission may subject you to involuntary civil commitment as a sexually violent charge upon police of your sentence. Counsel, do you stipulate to a factual basis of identity for the purpose of the admission? I will. Purpose of the admission.
Based on the colloquy, the affidavits of violation, the admissions entered, the court will, and the finding of competency, the court will find that the plea is freely, voluntarily, intelligently made with advice of counsel as a best interest plea, and the court will adjudicate the violations as admitted. I will now proceed to hear evidence or arguments regarding disposition of the violations. And does either side wish to lead off? Mr. Chandler for the defense.
We're just touch on the chase to the case that was fine. Mr. Casey's scores with the amended score, she was just under 66 months. We'll have 115.87 points, 116 plus 66 months, so they'll score 65.9 months essentially. So for purpose of my argument, I'll just call it 66 months. Mr. Casey is asking the court to sentence him to 68 months, credit for all time served.
So that credit would be the prior 5 years prison plus any and all county jail time.
Correct. The two violations, as the court can see, they are not Condition 5 violations, they're technical violations, they're changing the address and leaving the county. It's not a situation where probation couldn't find him or absconded. Frankly, the people that have absconded have a lot of times shorter sentence than 66 months. So what that would equate to him, or 68 months, or asking for 68 months, what that equates to him, he has been incarcerated since September on this violation. It's now June 11th. So he's gotten roughly 9 months in. He would, in fact, with a 68-month offer, he would have, or 58-month sentence, he would have completed it already. Obviously, he'd be transported to DOC for, if they still transport to DOC to confirm that he's got that time in. I know with COVID, they're maybe not transporting. I'll leave that up to DOC.
And Mr. Casey understands that that is an administrative matter between the jail and the prison.
Yeah, I spoke to Captain Kennedy at the jail yard. She indicated through classification modeling that if I was sentenced to that, they would implicate immediate processing the paperwork, and I couldn't be released from the jail, and may not have to go to the DOC to be released. Their process that paperwork.
Okay, but obviously, Mr. Casey, you understand that's beyond this court's control as to how that will be implemented.
Yes, sir.
All right.
So the basis for that, since Mr. Casey has been incarcerated since September, he has participated in programs in the jail. I have a certificate of completion of a Bible Basics study course that I have for the court.
Are there more, Mr. Chandler?
I have one other.
All right.
Yes.
If you want to pass that up to Officer Harrison, he's got a second one.
Oh, okay. And the second exhibit.
It's a gold embossed, I see.
It is. That's very nice. The second is essentially an admissions letter from St. Matthew's House. Mr. Casey is intending to admit himself into the Justice Place program on his release from either Collier County Jail or DSC, whichever facility he's released from. The bed available, I believe, for a period of 90 days. That letter is written April 9th. So he's got just under 30 days to get out and get in that program before he loses the bed space. I know that is not part of the sentence that's being requested by the state or by the defense. I know that he's not, I don't think anybody, I think the state's original offer would revoke and terminate. Assuming the court revokes and terminates, that is where he plans to go when he's released.
And you are asking to revoke and terminate,
Yes.
correct?
Yes. We're asking to revoke and terminate. There would be no mechanism in which really to monitor the use adjustments in place. I mean, the court could order it, but without him being on probation, there's no way to necessarily enforce that. Other than he has taken the steps to do that. This isn't someone that's saying, "Oh, I want to do this," or "I think I might do this." There has been initiation. In fact, that letter I can tell you, or that admissions letter I received from the Clark County Jail, from jail administration that sent that to me. So what we're asking the court to do is sentence Mr. Casey to 68 months. Given the technical nature of the violations, that will be sufficient. That is a sufficient, more than sufficient sentence, given the technical.
Any comments on the danger finding?
You know, I don't believe that Mr. Casey would be a danger to the community, because we're here on a violation of probation. I'm here on the underlying case. The underlying case was dealt with 6 years ago.
Well, actually, I think the court would disagree with you on that, Mr. Chandler, because now that he's being sentenced on the whole case, I think I have to consider what is an appropriate disposition given all of the circumstances.
Well,
Now, I agree that the nature of the violations do weigh into the analysis as to how much compared to other factors, but I do think it's a totality of the scenario review.
you know, he's already been sentenced and punished for the underlying offense. That he did 5 years in prison for that. You know, and as far as the facts of that offense, to be absolutely honest with you, we don't get the discovery on the underlying offense. So as far as we get him on the violation of probation, so as far as the underlying acts and events, I can't really argue that because I was never given that discovery. So it would put me in a very difficult position if the state's going to come back and argue facts from 2015.
I think at a minimum, the state has in the past in other cases, and most likely in this case will argue, just based on the nature of the felony, that it being a violent offense.
Well, and I'm not going to argue that it would not qualify as a violent offense, but are we back here because Mr. Casey committed a violent act? And the answer is no. We're not back here. If we were here on a condition 5 where it was a battery or an assault or anything that could be construed as violent, I would have no comments on that. Well, we're not here on some violent act. We're not here on another threat or anything like that. We're here on technical violations that I don't think anybody can say were violent in nature.
Okay. Anything else?
Yes.
State's argument?
Yes, Your Honor.
And Your Honor, Mr. Casey may want to address the court.
After Mr. Ashby.
Yes,
Yes, Your Honor. State is asking that you revoke and resent the defendant to 70 months in the Department of Correction.
770.
7-0, Your Honor.
Okay, so the parties are not far apart in the recommendations, Mr. Ashby.
Yes, Your Honor.
What would distinguish the state's recommendation as being the more appropriate given the relatively small difference between the parties?
Well, Your Honor, the state is pointing to a couple of factors. One obviously is the defendant has already done a 5-year prison sentence on the charges, on the underlying charges on the outset. The defendant is also designated as violence on this special concern. He does have a significant criminal history. Noting that the violations are technical in nature, they leave the time of residence as well as changing an address without permission of his probation officer. However, the charge for which he was on probation was an aggravated battery with a deadly weapon. It is a second-degree felony. It is a serious offense. Looking at the defendant's history, you see that he does have prior history of burglary, a second-degree felony burglary. He has 3 battery on law enforcement officers, numerous felonies, numerous misdemeanors, 3 counts of felony driving license suspended or revoked, a multiple fleeing and looting is third degree, grand theft of a motor vehicle, burglary of an unoccupied dwelling, 2 burglaries for unoccupied structure of conveyance, and 3 convictions for grand theft. The defendant does have several felony convictions. Noted in his score sheet is that at this point in time, he scores, even with the amended score sheet that he before coming, he's still going to score very close to the 66 months that is on the score sheet. The defendant committed 2 violations while on probation. The nature of those violations being that he left his county of residence, and at first the initial information was that he left his county of residence, was possibly holding his daughter hostage. It turned out later that was not the case. However, it appears that he left his county of residence to confront another individual, in a situation that involved his daughter, which is not fully explained at this time. But, Your Honor, as it is, the defendant violated probation. He's already served 5 years for the underlying offense. What essentially the state is asking for is to go from just his underlying 60 months to what he is, the state recommendation, which would approximately be 10 months. It's a little less than basically a fresh year on the violation of probation. They believe that is appropriate, given that he did commit a new law violation, essentially a 10-month law for violating his probation. The state believes that is a fair resolution to the offense. As far as I was suspecting the court's inquiry about the data community, obviously the defendant does have several offenses that would be considered violent in nature. There's also a child abuse as well as a domestic violence injunction, as well as other batteries in his criminal history. Obviously the burglary as well as the battery on the law enforcement officer. These violations, however, are stated with the Cocaine report say that in their very nature is not per se violent. He left his county residence and he went to and he did not inform his probation officer that he wasn't living where he said.
So just to be clear, the state is not alleging that there was evidence of any referenced hostage situation of some type?
Is the state's information that there was not a hostage situation? That was what was relayed to the probation officer who take full police department.
But that should not be considered against
No,
Mr.
Your Honor,
Case.
it was not. That was a misunderstanding.
Okay.
So that was cleared up. It seems that he was actually going to the aid of or going to the aid of his daughter to confront another individual, and that seems to be the issue. Either way, that was the basis for him leaving the county residence. State would defer to the court as to the finding of the age community standard. The court
So let me clarify, the state is advocating for a danger finding or deferring to the court on that?
the state is deferring to the court. State is not taking a position one way or the other as to whether the defendant is dangerous.
Okay. Additional? Mr. Chandler or Mr. Casey, depending on what you prefer, Mr. Chandler?
Yeah, I'd like to sum up with the state.
Mr. Chandler, do you wish for him to? All right, go ahead, Mr. Casey.
Your Honor, you look at the circumstances, I realize what happened here, and I want to advise the court firmly what actually happened here. My daughter called me on I contacted her on a Facebook Messenger, and she told me about she had been abused by this individual she was living with for a couple of years. I did a check with Lee County Sheriff's Office and investigated some reports and some issues related to it. And I seen the report suggesting what happened to my daughter in the situation related to him, and I seen her black eye, and I seen her nose look like it was broke in the picture. My daughter's name is Brianna K. Challenger. As we were communicating, she told me that this individual had committed a murder in front of her in the past, and which is still unsolved. I spoke to crime investigator, major crime investigator Pippin with the sheriff's office. Spoke to him, he came and talked to me, he related to the same information. I told him it looks like a bad spouse. syndrome here, that something needed to be done since I was in jail. I spoke to this guy. I'm still in the process of that happening, and I'm hoping that if the court was to construe releasing me, so we bring some justification, we bring some justice to that situation related to my daughter and the individual at home.
Now, you
So-
understand, Mr. Casey, that you cannot engage in vigilante justice or engage in violence. You must go through proper lawful authorities for her situation.
I did, and
Well, I'm
this
saying
is-
not only now, but in the future.
Yeah.
Okay.
I went to take Cole. I went to her house after I left my motel room, which I was at. And, the individual was in jail and he was being released that day. The Department of Children and Families was coming. The first time I ever seen my granddaughter was the day I walked in there. I haven't seen my granddaughter and I hadn't had a relationship with my daughter in 15 years. So I was really concerned about her well-being and the circumstances that she was relating to me. The reason why I was going to bring up the temporary insanity issue and this issue was the fact of where I was at. I wasn't on my medication when I left the county. I wasn't even thinking to call my probation officer. When my daughter told me this, I got frantic and I took off with my friend who drove me in a cab over there to deal with the situation. When I arrived there, the Department of Children and Families was there after, well, they came shortly after I was there for a little bit. The Department of Children and Families came. My daughter was dirty for a Xanax, what she told me. I advised DCFS. I told DCFS what was happening, what was going on. So I was really trying to relate to them to bring some closure to what was going on. And I told them I wanted my last grandbaby out of that house. And they said, well, the best thing you can do is get your daughter out of this county. I said, I'm going to do that. Had this would have went to the hearing, all this would have came forth. The DCFS would have came and testified about that position and the issue related to it. My daughter's fighting for custody right now. I do not know the position with this individual and what's going on. I just know that I want to bring some closure to it, and I want to do it in a way where I got to deal with law enforcement. I've dealt with issues in the past with law enforcement, assisting them with several other cases. There was an unsolved matter that I resolved with law enforcement when I was in prior, and that was the Michael Cook and Nicholas Chandler case. There was an issue of
So, Mr. Casey, we're digressing a little bit there. Let me just,
I don't want to get
on this matter, you're saying you would like to be able to, at the soonest appropriate time, be able to assist your daughter,
Yeah,
and you're willing to do so through lawful authority.
yeah, and that was the reason why I didn't take the state offer too as well, was because that I got to deal with this with my daughter for 8.5 months. I've been going crazy, not knowing what's going on. I'm really worried for my daughter's sake. And I really want to try to get these things as far as I can. And it's been hard. You know, I've been going through a lot, but you know, I'm just trying to get this result. I know what my prior is like, but I'm headed for a better future. I'm looking for something better in my life. I see a new plan. I see a different way. And, you know, I've been reading the Bible, I've been studying it, and understanding who God is in my life and understanding who I am. And I want to change what I've done in my past to make it better for the community and for myself. And I got to start dealing with my grandbabies and my children. And that's what I'm really trying to do. I don't know how much life I got left, but what's left, I'm going to give it to God and do what I got to do. And whatever justice happens today, you're the deciding factor. And I trust your decision and everything you want because I know who you are. So I just want, whatever you got to do, you go ahead and do what you have to do, but I trust you too.
All right, thank you, Mr. Casey. Mr. Chandler, anything else to add?
Yes, sir.
Any cross-examination, Mr. Ashby?
Never
Any additional state comment?
mind. Never
All right, I think I can make a decision at this time. Mr. Casey is before the court on a plea to the bench and a violation of probation. The two violations admitted. Well, first of all, I've already found him competent. He has had ongoing mental health issues for a good portion of his life. That was documented by Dr. Ewing. One moment. Let me just get to the right.
Because I don't know, any either of us asked this before we get done, but I would ask the clerk. Probably not take judicial notice because I don't think it's in the public work file, but obviously take into consideration Dr. Ewing's report.
Yes. Mr. Casey was placed on supervision and following a 5-year prison sentence on a second-degree felony aggravated battery with deadly weapon and gun license suspended or revoked, both arising from the same incident at a McDonald's in the drive-thru, where the probable cause affidavit indicates that for whatever reasons he became impatient and started hitting the vehicle ahead of him with his own vehicle, and then that's what caused law enforcement to respond. The affidavit alleged changing residence without procuring the consent of probation, as well as leaving the county of residence. Mr. Casey had left the motel where he'd been staying a few days before the probation officer went to the motel. Mr. Casey has commented about the circumstances that led him to leave the county, as he says, to assist his daughter in her domestic violence situation. Mr. Casey does have a violent felony offender of special concern designation that's undisputed. He has presented a certificate of completion of religious studies while in the jail, as well as indication he's making arrangements on his own with St. Matthew's House Justice Place for possible substance abuse or other counseling. The parties are not far apart here. It's a 68-month versus a 70-month decision. It is an adjudication. The monetary amounts I don't think are in dispute. I assume there's a prosecution cost of $100. Were there any investigative? So just carrying forward any previous amounts to collections. There's no dispute that probation should be revoked, and he would be sentenced at this time with no further supervision. The court must also, the state has deferred to the court. The defense does oppose a danger finding in this case. It appears that yours truly, when presented by probation with the affidavit back in September of 20, issued a no bond warrant in this situation. It's my understanding Mr. Casey has been held continuously since then.
That's correct.
And he does have significant credit of all of the 5 years prison plus any and all county jail time, which will bring him right up to, depending on which recommendation is accepted, his release date. Take a look.
And from state calculation, that credit would be 255 days for prior prison.
Does the defense agree to 255 days Collier County jail credit, or do you wish to have it calculated by the jail? I mean, I can just have it calculated by the jail if that's what you prefer. That is agreed?
Yes, sir.
So that's how much again?
It's 255 days from September 30th plus the prior prison.
Thank you for providing that.
That would be 8 months and 13 days. So if the court did sentence him to 68 months, he's overstayed that by 13 days. Actually, the game time would be 30 days and 13 days. He's overstayed that.
To sum up the state's recommendation, it basically is focusing on the underlying offense, his designation, the prior history, and that with this, it would give him a fresh year, essentially sentence from when I guess in addition to the prison time. Mr. Chandler has argued that the nature of these violations don't warrant the additional time involved, points out the technical nature of them and his progress individually since then. I've considered everything, and at this point, I am impressed with the defense argument, and I think Mr. Chandler makes some good points. I think Mr. Casey spoke articulately. I tested him a little bit, and he did respond appropriately that he would attempt to work through lawful means to protect his daughter. These violations do not cause me, as I agree with Mr. Chandler, to believe that makes him a danger. His underlying offense is what it is, but he served time on that. At this point, I will grant the defense request for the 68 months credit all time served as previously expressed, and find with the order to follow that he is not a danger to the community based on all of the circumstances considered. So, Mr. Tacey, this rewards your efforts and your insight into your own situation.
It's federal fight. It's still pending in federal court, Your Honor.
Okay. Huh?
2254.
Just try to channel it in a positive direction.
Yes, sir.
This will give you that opportunity.
Yes, sir.
All right, so ordered.
Thank you, Your Honor.
That's not,
What's that?
that's not.
Was not. Yeah, order to follow.
Yeah, Your Honor, I'll look at the implemented voice.
Thank you.
That's fine, thank you.
All right, Madam Clerk, here's the two exhibits from the defense, 1 and 2. Either one, doesn't matter the market. No. Well, Mr. Chandler, does he need the certificates or have they are admitted evidence?
I think.
If he needs them, that's fine. They've been referenced.
You can get them in there.
Okay, very good.
I know the state mass letter, we have a copy of.
Thank you, Your Honor.
Let's do the plea agreements, please. Any preferred order? All right, they're both at the jail?
Yes, sir, both over
All
here.
right, whoever they have first. You have the score sheet on Mr. Tacey?
Your Honor, I have to.
Oh, you have to redo it. Okay, that's fine. And I'll submit the written order on danger.
I'm gonna go with Mr. Nito.
Mr. Nieto, tomato, tomato.
This is from this morning.
Contaminate my trainer
No.
then. Try one of these masks.
Don't ever let me say famous last words in here in the morning.
Yeah, don't ever underestimate.
Yeah.
All right. I forgot that they're not by audio visual. I was looking at the connection. It's in person.
Yeah, the day we got them coming over. Mr. Lyon isn't being present, and Mr. Overholzer.
Overholzer, yes. All right, hello, Mr. Nieto. How do you say the last name?
Nieto.
Nieto, exactly. So I thought. Not these other pronunciations. All right, Mr. Ward for the defense. What is the case number, please?
This is 21 CF 412. This is the Nieto is prepared to enter no contest plea as charged with driving while license suspended revoked that the condition of traffic suspended. The agreed upon sentence with the approval of the court will be an adjudication of guilt, 24 months of state probation. On that probation, Mr. Nieto will have to complete an 8-hour driver improvement course and complete 100 hours of community service. And the community service hours will not be bought out. The court costs of $415, $100 cost of prosecution and defense, 50-hour public defender application fee.
No investigative?
No, that's a problem.
Any other state clarifications?
No.
And Mr. Nieto, do you understand and accept the terms? Any questions? Please raise your right hand and be sworn by the clerk.
Did you say they not violate?
Yeah, I apologize.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. May you lower your hand. Please answer the state's questions.
Thank you, Your Honor. Sir, can you please state your name and date of birth? What are the last 4 digits in the social security number? Have you ever been known by any of the names or aliases?
Yes,
It's in the, oh, it's not good for you.
Romero, yeah. I don't know if I remember it.
It looks like he's reviewing a number of documents there, Mr. Ward.
Rodolfo Rodriguez,
Right. And
Grand Nichols.
and were you ever arrested under that name? Were you ever arrested under that name?
Yes. Back in, 89,
And sir, where were you born?
in Texas.
How far did you go to school?
Yeah.
Can you read, write, and understand the English language? Are you under the influence of any drug or alcohol? Are you under the influence of any drug or alcohol?
No.
Are you taking any medication? Are you suffering from any mental conditions or disorders?
Any what?
Are you suffering from any mental conditions or disorders? Do you understand why you're here today?
Yes.
Sir, in 21 CF 412, you can charge in a one-count information with the following charge. Driving a license suspended or revoked at a habitual traffic event, a third-degree felony, punished by up to 5 years in the Department of Correction. To that charge, how do you wish to plead? Guilty, not guilty, or no comment? So do you understand that driving a license suspended or revoked is an enhanced offense? Meaning, if you're convicted of this offense in the future, you can receive more jail or prison time or a higher fine. Do you understand that a third driving license suspended or revoked can be charged with a felony? Do you understand that by entering this plea, you're waiving the right to a trial by jury? Do you understand you're also waiving the following rights? Your right to have a jury determine your guilt or innocence. Your right to see and hear the state witnesses testify and have legal or question. Your right to subpoena, call your own witnesses and submit evidence on behalf. Your right to testify in your own defense or to remain silent. And your right to make the state prove the charges against you beyond a reasonable doubt. Do you understand, sir, that you're waiving all those rights by entering this plea today? Counsel, reserve any matters for appeal?
I have not.
Mr. Nieto, do you understand that you are given your right to appeal on all grounds except whether this court can impose this sentence? So I'm showing you your score sheet. Have an opportunity to review this with your attorney?
Yeah.
I'm showing you your score sheet. Have an opportunity to review this form with your attorney?
Yes.
It shows you that you scored a total sentence points of 9.8 with a lowest permissible prison sentence in months of 0. Sir, do you agree that the score sheet is accurate?
Yes.
Also, hold a plea of guilty and no contest for criminal charges form. I reviewed this form front and back.
Yes.
There's a signature on the back that says defendant's signature.
Yes, it is.
Your signature tells me that you read and understood the rights listed on the plea form. Do you in fact read and understand the rights listed on the plea form?
Yes, I do.
Do you have any questions about the plea form at this time for your attorney?
Yes. Oh, do you have any questions on that? No.
Sir, otherwise contained in the plea form and what we just discussed on the record, have anyone promised you anything in exchange for this plea? Then no?
No.
Are you entering this plea of your own free will?
Yes.
Are you being forced or threatened by anyone?
What?
Are you being forced or threatened by anyone?
No.
Are you pleading because given your option, you believe that this plea is in your own best interest?
Yes.
Do you understand, sir, that there is no guarantee that you will be able to terminate your probation early?
Yes.
Are you satisfied with the advice and counsel of your attorney?
Yes.
Has he done everything you've asked and answered all of your questions?
Yes.
Have you gone over all the discovery in this case with your attorney?
Yes, I have.
Have you had sufficient time to consider the offer, the charges, whether you want to accept the state offer or go to trial with your attorney?
Yes, I have.
Do you need any more time to speak with your attorney?
No, sir.
So I'm aware of any physical evidence that can be tested for DNA to exonerate you. Do you understand, as a result of this plea, no physical evidence will be tested for DNA? You understand that if you are not a U.S. citizen, you may be subjected to removal or deportation as a result of this plea.
Yes.
You understand that if you're deported as a result of this case, it will not be a basis to withdraw this plea.
Yes.
You need any additional time to discuss this with your attorney.
No,
Sir, if this offense to which you are pleading is a sexually violent offense or a sexually motivated offense, or if you're previously convicted of such an offense, this plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. Do you understand this warning, sir?
Yes.
Counsel, do you stipulate the factual basis of venue to the purpose of the plea? The state has a police report.
Any additional defense comment or request? Based on the plea agreement, plea colloquy, the plea of no contest and arrest affidavit facts, court accepts the plea agreement, approves the terms as agreed, adjudication of guilt on the charge, 24 months probation, report upon release. I will allow Mr. Nieto, since it's late today on Friday, to report on Monday.
Yes.
Does there need to be a transfer of supervision? 8-hour driving school during the term of probation, $100 community service, monetary amounts all as announced. Is there any objection or request for hearing any monetary amounts? Any other details?
Nothing to say.
Mr. Nieto, any final questions? I've approved everything. What part of Texas were you from? West what? I'm not familiar with it. North, south? Okay, south. Okay. Okay, how does the Lone Star State southern portion compare to South Florida?
Well, I was raised here.
Oh, okay, so you just born there. Okay, all right. Thank you for resolving your case. All right, next is Mr. Oberholzer when we're ready. All right, Mr. Oberholzer now present. What is the case number, Mr. Ashby?
This one case numbers 21 CF 190 and 21 CF 529.
All right, and Mr. Ward for the defense, what are the terms?
Your Honor, Mr. Oberholzer is prepared to enter a no contest plea as charged in both cases. There'll be similar sentences in both cases. There will be legal adjudication, 3 years of concurrent state probation, no contact with the confidential victims in each case.
How many individuals?
There's one victim in each case. Your Honor, the state has prepared orders as such. There'll be a no trespass order for all publics in Conroe County. On both probations, there'll be an anger management course and an anti-theft course, $415 court costs in both cases, $100 cost of prosecution and defense in both cases, $50 public defender application fee. In 21 CF 529, there is a $259 cost of investigation to the Collier County Sheriff's Office. There's no investigative costs in 21 CF 190. And in 21 CF 529, there's an $800 restitution order to the top.
Any state clarifications?
No, Your Honor, no terms.
Mr. Oberholzer, do you understand and accept these terms?
I do, Your Honor.
All right. Any competency issue? You can remain seated, Mr. Oberholzer. Thank you. No competency issues? Is there any objection to the plea agreement from any alleged victim or law enforcement?
No, Your Honor.
And it's agreed that there will be no return to any Collier County-based Publix location?
That is correct.
So, Mr. Ward, will Mr. Oberholzer continue to reside in Collier?
Yes, Your Honor. That's why he was on probation. He was, I believe, trespassed from the Publix is in Pernack, and that could continue beyond his probation. I explained that to Mr. Oberholzer.
Okay. Obviously, it's difficult to live in Florida without, at some point, walking into a Publix, but he's figured out other grocery choices.
Yes, Your Honor.
Okay.
Mr. Oberholzer,
All right. And Madam Clerk, you need anything clarified?
No.
And there was no objection from any victim to the plea agreement?
Correct.
Any victim impact desired to be presented?
No, Your Honor.
Mr. Oberholzer, do you believe this plea agreement is better for you than having a trial in these cases? And has he been sworn, Madam Clerk? All right.
Do swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. Please answer the state's questions.
Thank you, Your Honor. Sir, can you please state your name and date of birth?
John William Oberholzer, 1773.
Sir, what are the last four digits of your social security number?
5304.
Have you ever been known by any of your names or aliases?
I have not.
Where were you born?
Baltimore, Maryland.
How far did you go to school?
College.
Can you read, write, and understand the English language?
I can.
Are you under the influence of any drugs or alcohol?
I am not.
Are you taking any medication?
Blood pressure.
Are you taking that medication as prescribed?
Yes, sir.
Are you taking that medication today? Does that medication affect your ability to understand these procedures? Are you suffering from any mental conditions or disorders? You understand why you're here today? Sir, it's starting with 21 CF 190. In that case, you've been charged with a one-count information of abuse of an elderly disabled adult without great harm, from disability or disfigurement, a third degree felony, punishable up to 5 years in the Department of Corrections. For that charge, I need to plead guilty, not guilty, no contest. Sir, in 21 CF 529, in that case, you've been charged with a one-count information with one count of grand theft, a third degree felony, punishable up to 5 years in the Department of Corrections. For that charge, I need to plead guilty, not guilty, no contest.
No contest.
So you understand that theft is an enhanced offense, meaning if you're convicted of theft charge in the future, you get more jailable first time or a higher fine.
Yes, sir.
You understand that a third theft charge, sir, can be charged with felony.
Right.
You understand, sir, that these charges become consecutive, that means one after the other. The maximum sentence you face is 10 years for the Department of Corrections. You understand that by entering this plea, you're waiving your right to a trial by jury. You understand you're also waiving your right, you're also waiving the following rights. Right to have a jury determine your guilt or innocence. Right to see and hear the state's witnesses testify, have your word questioned. Right to subpoena, call your own witnesses and submit evidence on behalf. Right to testify in your own defense or to remain silent. And your right to say proof of charges against you beyond a reasonable doubt. So you stand for this with all those rights. Counsel, reserving matters for appeal?
I'm not.
Mr. Overholzer, do you understand that you're given the right to appeal on all grounds except that this court can impose this sentence? Take a look here. So I'm showing you your score sheet. Your opportunity to review this with your attorney. Holding here my hand shows you score a total sentence point of 38.8 for the lowest permissible prison sentence in months of 0. Do you believe the score sheet is accurate? Also holding a plea of guilty of no contest from the charge form. If you this form, find that.
Yes.
There's a signature back that says defendant's signature.
Yes.
For the signature doesn't get you right and who's good right to this long free form. Did you in fact read and understand right to this long free form?
Yes.
So I'm also holding an order, confidential order of no contact, well, two confidential orders of no contact, as well as a confidential order of restitution. For the confidential order of no contact, state that you will have no contact with the named individual either directly, indirectly, or any third parties. For the confidential order of restitution, state that you will pay the amount of $800 to the named individual, not a condition for probation. So if you have any objection to these orders being entered against you, counsel, do you have any objection to these orders being entered? Charging what is contained in the plea form and what we just discussed on the record, has anyone promised you being in exchange for this plea? Are you entering this plea of your own free will? Are you being forced or threatened by anyone? Are you entering this plea because given your options, you believe that this plea is in your own best interest?
Yes.
You understand that there's no guarantee that you'll be able to terminate your probation early? Do you understand that as part of this negotiated resolution, you're going to be receiving a withhold communication? You understand that that means that at this point in time, you're not going to be considered a convicted felon. However, sir, if you violate your probation and you're adjudicated guilty of the violation, you would also be adjudicated guilty of the underlying offense. You understand that, sir? And at that time, sir, you will become a convicted felon. Are you satisfied with advice and counsel of your attorney?
Yes.
Have you done everything you've asked and answered all the questions?
Yes.
And you have sufficient time to consider the offer, the charges, whether you want to accept the state offer or go to trial with your attorney. And you reviewed all the discovery in this case with your attorney.
Yes.
And you need any more time to speak with your attorney. So I'm unaware of any physical evidence that could detect for DNA to exonerate you. Do you understand how the result of this plea, no physical evidence will be tested for DNA? You understand that if you're not a U.S. citizen, you may be subjected to removal or deportation as a result of this plea. You understand that if you're deported as a result of this case, it will not be a basis in fraud. Do you need any additional time to discuss this with your attorney? Sir, if the offense in which you are pleading is a sexually violent offense or a sexually motivated offense, or human person convicted of such an offense. This plea may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence. Do you understand this warning, sir? Counsel, do you stipulate the factor basis of committing for the purpose of the plea? And I say, Counsel, please report.
Any additional defense requests? Based on the plea agreement, plea colloquy, the pleas of no contest, and arrest affidavit facts supporting the same, court accepts the plea agreement, withholds of adjudication in each case, concurrent terms in each case of 3 years regular supervision, reporting no later than next Monday, since it's late on this date on a Friday. No contact orders as submitted or announced. No trespass all Collier County public locations. Anger management course to be done. Other conditions, Mr. Ward or Mr. Ashby?
It's also
Also ordered, and the monetary amounts as mentioned. Any other terms to be clarified? Thank you for resolving your case. Please step over here for the prints. And that just leaves one matter remaining, I believe. Yeah, let's take a 5-minute break before we start that. I'm just finishing the Casey danger order here.
Okay, I took us off the record.
Yeah, that's fine. Madam Clerk, here's the Casey danger, no danger order. On this one, hopefully you can just copy that because it has it.
Okay, from that.
Yeah.
Okay.
You need a break, Madam Clerk?
I'm good, Judge. I'm breaking with you.
Yeah, I'm just going to take 5 minutes now, and then this is, I think, the last remaining matter. Let's see. Yeah, Mr. Lyons, which will be 17 CL. Well, we'll come back and address it. Oh, I've got more orders here. Mr. Oberholzer, I think that's the name of the lead character in the last James Bond movie. Franz Oberholzer, otherwise known as Spectre.
Okay. I couldn't remember the last name on it.
I believe that's what it is.
I think it was Miss Esther. One of our, she was a triple O.
Triple what?
Not a double O, but a triple O. Or the Social Security was
Oh,
triple O's.
wow.
So she was not only a double O, she was a triple
Wow.
O. Didn't know for that. Being a little goofy.
It's Nadal versus Djokovic.
I saw it this morning.
Was it already going this morning?
No, I saw it in the news this morning.
Yeah.
The finals.
No,
No,
it's,
semifinals.
it's rare that they, by seeding accident, they end up in that way.
Mm.
I think one of them would have been with February if he wouldn't have dropped out.
So they had quite a few people drop out of it's the French Open, right?
Yeah, I think because Wimbledon is getting ready to start in a couple of weeks.
Mm-hmm.
So,
So everybody wants to make sure they're healthy.
well, I know he does. He messed up his knee.
All right, 5 minutes, we'll get underway.
All right, all rise for the recess, 5 minutes. This one there.
Oh, I have one. Oh, it's a cool thing.
Yeah, I already told you we were gonna go first.
Yeah, let's go first.
I'm not going to decide what it is. So that goes, so fast.
Oh, my gosh.
Oh, he almost fell down over it.
Oh.
I almost fell off my chair.
You know what, I'm sure we can.
You know what? You had that almost with a straight face. You know, I'm crying a little bit. You're what? You got any of that lunch yet? Well, I told you to go up and get a couple of bites. I told you.
It would have been my time. I would have been on the got first, and then you call it, I would have been here. So I wouldn't your answer didn't work. I thought it was 1:30. So I thought that we were going to go.
You know what? Yeah, you could have actually had too much. I didn't realize it was.
I didn't either at first. It was like I had a calendar reminder saying it's doing it.
Man, you guys were loud over there. I'm talking. Oh yeah, everybody looked over at you.
I wasn't talking.
Peter Roy,
He was talking. You thinking I was talking?
you were talking. You two were
I
talking.
just think,
Everybody looked at you, and that's what I said.
it wasn't me talking. Please. Wasn't me, I was just doing a listening.
I'm hearing you guys talk, but man, everybody could hear you. You were interrupting the forward.
I didn't hear him.
Yes, you did. You looked over
Oh, did I?
there. Yeah. You looked over there, Jess looked, Brian looked, Chandler looked over there.
Oh, I thought I was looking at him telling the story and saw time.
Oh. No, that was before the.
I thought that's why I did.
You wouldn't say, like, I haven't seen my daughter in like 8 years or 15 years, and all of a sudden now I gotta go to the rescue. I'm like, what?
Oh, yeah.
Okay.
It's right now. Yeah, that's why I'm looking this way.
Your face says it all.
Oh my, yesterday, was it yesterday?
I know.
I was like, no, it was Wednesday.
It was Wednesday.
Yeah, there was Wednesday when we were doing that. Yeah, and I saw the way you were, first of all, first the attorney answered the questions for the match, and that's why I was like, and but your face was your issue, I was tired.
You know, who's answering the question?
The attorney was doing what's going on. I can't believe it. And it's, and I'm like, what are you doing? You can't make this stuff up.
No.
I was getting, I'm right there, it's your next. And I was just sitting there, so like, I should have come and I didn't say it, but I didn't do it. The second time, I was looking going,
Yes. Yes. And I bet you that was his girlfriend, she's like, yeah.
oh, I'm sure. Yeah. You know it's what I'm talking about.
Oh my God.
I don't know if it does pick up on it, but I'm just sitting there going,
I know, that other girl was
Well,
trying
you
to.
know what, at that point in time, my knees, people probably hurt me, you know.
I just couldn't believe what I was hearing. I wanted to be like, stop getting ready to like, go back there somewhere. I'm not gonna answer these questions.
The truth is stranger than fiction.
You always give you strings and cases.
All rise, Carter County Circuit Court is back in
All
session.
right, the final case, Mr. Lyons, please. 17 CF 2296. Mr. Barger for the defense, Ms. Mason for the state. Awaiting Mr. Lyons.
Bring him out, Your Honor. Bring him out.
All right, Mr. Lyons is present. Welcome back. Please be seated. Mr. Barger, will this be a plea to the bench? Very well. Defense has gone over the differences, Mr. Barger, between the bench plea agreement, and a full hearing with Mr. Lyons?
Yes, sir.
Very well.
Now, before we get started, there are 3 allegations to the violation of probation, 2 of them are condition 5s, both at the same date. The state would be asking the court to dismiss one of the condition 5 violations, and I prepared for it.
Yeah, that did seem odd in the affidavit. So it's actually only one condition 5 alleged.
Judge, there actually were 2,
Oh,
but the state did not proceed on one of them. There was no probable cause found for one of them.
okay.
And so, in reviewing the misdemeanor cases, I believe that we should not be proceeding on one of them.
Okay. Does it matter which one of the 2?
No,
They're both alleged the same. So one of the conditions.
I'll just say that's the first one.
All right. All right. Madam Clerk, any clarification on that? All right. So there's just one condition 5. The other one is being dismissed at the request of the state. All right. And Mr. Barger, any preliminary comments before the colloquy?
Negative.
I also know that the defendant is a violent felon for their special concern. I do have a little prepared, and then because you know, completely don't know around about that now, about that. We have to be
The form, you mean?
yes, ma'am.
I can wait on that. Mr. Barger, it's undisputed that Mr. Lyons has that designation.
Yes, sir. They charge itself.
Okay. And are we ready for the plea colloquy at this time?
Yes, sir.
And please raise your right hand and be sworn. Mr. Lyons, you can remain seated.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. Please answer the state's questions.
Would you state your full name and date of birth?
my name is James Patrick Lyons, 91976.
And what are the last 4 digits of your social security number?
37.
For your name? Where are you born?
I'm going to be short.
And how far did you go to school?
I graduated high school and then I was in college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you prescribed any medication?
No, ma'am.
Are you suffering from any kind of mental condition or disorder?
No, ma'am. No, I'm not. I suffered a little bit of like depression when. Yeah, no, I never been trying to play that.
Thank you. And if this one, as we stand here today, you feel that you were able to think clearly?
Yes,
Okay.
I'm. Yes, ma'am.
Okay. Do you understand what we're doing?
Yes, ma'am.
You admit that you were adjudicated guilty and placed on probation in case number 17-2296 for one count of burglary causing damage $1,000 or more.
Yes, ma'am.
That's a punishable by life felony. That felony is first degree felony punishable by life in prison.
Yes, ma'am.
At the time that you were placed on probation, were the terms and conditions explained to you?
Yes, ma'am.
Did you understand them?
Yes.
You're allowed to both ways substantially violated your probation in the following ways. Condition 7, that you tested positive for cocaine on February 12, 2021. It also signed an admission to that you used cocaine on February 6, 2021. And condition 5, that you committed a criminal offense of violation of the injunction for protection against domestic violence on or about March 20, 2021. And misdemeanor case 21 NM 455. To each of those allegations, you wish to admit or deny?
I admitted to the cocaine, but I believe that we were going to confess to. We're going to admit. Well, we're going to. Okay, yeah, we're going to admit to both those charges.
Okay, so you're admitting to condition 7 and condition 5?
I never violated that restraining order, but I will admit to hearing Mr. Manalich that there's certain things that you can understand. I guess I'm putting, yes, I guess.
Just want to, do you want to take a moment to speak with your attorney? As to what you want to do in this case?
Yes.
All right, how much time do you need?
10 minutes.
All right, let's take a recess then.
Go back, they went back for, let's get you over there.
We'll go off the record.
Go forward with that, that's for us all.
Yeah, unfortunately, Your Honor, there's a case law that says that admitting to the arrest only is not sufficient for violation of probation.
So we need a full hearing on this, is that correct?
I believe that's where we're going.
So, Mr. Barger, it's a defense request to proceed only with one of the conditions admitted, is that correct?
Yes.
Okay, that would then require the state to have an opportunity to present evidence on both violations. I'm assuming because it was billed as a plea to the bench today, the state is unable to do that today?
That's correct, Your Honor. I actually told the witness because it was going to be a plea to the bench.
All right. So we would proceed to the next available hearing date, which is, I believe, Madam Clerk, July 11 or more about? Let me take a look. I've got the all date somewhere here.
July 14.
July 14 at 1:30 p.m. then for full hearing, and we'll address everything at that time. Okay, do you want me to take a further recess while you confer further or not?
Yes, sir. We can have 5 minutes.
All right, let me break one last attempt to see if we can go forward today or not.
Thank you.
What was all that mess going on during there?
It's making who?
Hernandez and Kate.
When?
When I was trying to get on the radio to have some of our people coming out, those three were acting like nuts.
I think that was like a doctor.
Yeah, that was the only number.
I think they had like a doctor's too.
Yeah, get on the
Well, we have a huge docket Monday,
Do we?
morning and afternoon. Tuesday, we have probation hearings in the morning and afternoon.
We have all of them without the keys. Calendar call, no.
Yeah, I don't see anything. He starts his trial today, first trial.
He comes back, he was asking the day.
So he's on vacation until the 21st. I'll probably be in the trial today.
Going with us?
I don't know.
Who's gonna be with us? You know who's going, right? Mm-hmm.
You wanna see the legal
I don't know. Carson already got one case set for trial with one case, so it must be going. Yeah. Why does he look so familiar? Oh, wait a minute. Oh, this is just the sentencing. This is, the trial, I did this trial with him. This is the school teacher from the Gulf Coast Charter Schools.
Yeah.
Mahia.
Oh,
I thought the name sounded
we
familiar.
just did that one not too long ago.
What he's accused of doing?
What he was found guilty of? That's with one of the students.
Almost.
Yeah, so,
At charter school?
yeah. So it's his sentencing.
Was it female? Male?
Oh,
There was a guy, I mean, his wife works there with him.
No, I mean,
his
was
sister
the
works there.
victim? We know the victim.
Oh, yeah, it was a girl. And that's what Nebraska did with,
Yeah, it's his last trial.
Yeah.
Yeah, that's what I do really can.
Oh, yeah. And that come back on Monday.
Yup. And he didn't buy the people no food. They
Yeah.
stayed there all day and all night. They did not feed us.
Yeah, I understand.
Was that kind of like an oversight?
Well, no, they thought maybe, you know.
Or is he trying to starve them out? That's bad.
And then people stayed
You know,
there.
it could have looked negative, if they think it might have been bad.
Mm-hmm.
Sometimes you eat and it clears your mind, and I don't need to eat.
You love that? Why do you do? Where are you? What's that?
He's ready to go.
Did he say he was coming back in 5?
Just call him, dude.
Yeah,
It's 325 on Friday.
You know what his five is.
I know.
325 on
I'll
Friday.
text Melissa.
Please. I'm sure he wants to be done too.
Yeah, he does.
Yeah.
I was actually in the courtroom that night. And it was stayed for me. That I was in the courtroom that Friday.
Was it Chuck? Because he was in the jury box and he fell asleep.
Chuck fell asleep in the jury box? At what
I
time?
think everybody was falling asleep. I was falling asleep.
And what you doing now?
I don't know.
I just sent Melissa a message to send the judge back down.
That's what happened, Council. We're gonna resolve it. Okay, no, I'm saying why you over there. Oh.
What do you mean resolve it?
We're gonna resolve it. We're just gonna play out.
Huh?
Yeah.
Oh, okay. Oh, all right.
That's me being reasonable. No, you know who bailed me out? Kevin Dennis. Because I want to be relax.
Yeah, he stayed out just walking around.
He texted me like at 8 o'clock. I was still there. I went, why?
Yeah.
I'll just get me done by 7 days.
I think you're right.
It's just cold and it's still in the garbage.
I was glad it was Friday because I was able to sleep in the next day. You didn't have to worry about coming to work.
Sure.
So I was.
That's great.
Yeah.
Here's my time.
I don't understand, like.
You couldn't put him back anyway. Well, we did 3 hours there.
I don't understand where you're going to close and to get into the work, especially on a case like that.
Yeah, no.
You know, you can't do that.
Yeah.
You know, and they thought it was gonna be okay after closing, maybe about 30 minutes that the lady said will be back with a verdict, you know, but it wasn't like that.
That's a hot case.
Yeah, it is.
It's a hot case.
Yeah.
I'm gonna go ahead and have him loaded in here.
Excellent. Like a big.
One brother, holding these other lines. That way when the judge comes in, boom, put him there. It's bada bing, bada boom, bing. You know? No, I'm tired, Lisa. I'm tired this week.
It's been a long week.
Yeah. I think that Sutton case is, maybe like 8 days.
Oh, really?
Yeah.
I mean, it sounds like an interesting case. I don't know. I might sit in here. I'm not sure. I give it 80 to 90%. Say I'll be here. You know. I think it's my rotation time up coming up anyway.
Well, you might as well spend it with us.
You know, the worst part is trying to pick a jury.
Mm-hmm.
That's the longest part of the trial.
It is.
I know they got my jury picked in 2 hours between me and the defense.
But I think it might go a lot smoother now because after the 21st, we can bring in more than just those.
Make it smoother.
Yeah.
Keep going over, sending over and over and over.
Yeah.
Yeah, no face mask, so you can see the facial expressions, get to hear her voice,
Yeah.
see their body language.
You can still hear them though, because the jurors are wearing those clear masks.
Yeah.
They have a hard, but they have a hard time hearing us sometimes.
Yes.
And then the ones way in the back. That was like, I started a trial on Monday with Mara in front of Judge Foster. And we had the people that were on the very back, the defense attorney couldn't hear them. So he insisted that we not go forward until.
I don't blame them.
Masks. Well, okay, because.
Well, yeah. Yeah, but if I was a defense attorney,
And it's
that's
been,
what I would
and
do.
it's been 4 years.
Well, that's why we put all the microphones in the back after the witness and just.
He
so
wasn't
hopefully
ready
we
to
don't get
go.
us the answers.
That would be nice.
He wasn't
Well, no,
ready to
how
go. He
am I
was
gonna
doing
see it?
anything he could to get this case continued.
Right?
Yes,
Because this is
exactly.
the whole case here that they
Yeah.
should have been.
That's what, I was thinking, the moment we walked in, it was like the excuses started.
Yeah.
I was like, are you kidding me?
Yeah.
But apparently we took a break and he called his hotel and was like, oh, I guess I gotta extend this another day. Yeah, because he booked a 1-day hotel for a 4-day trial. Yeah. He was supposed to be there till Friday and he was like, I only booked for a day.
Yeah.
Next year.
Dave Wooden, he's in there.
I told Mara, I said, if he doesn't
If he doesn't find something that will stick to get a continuance, he's gonna, I guarantee he's gonna say or do something to intentionally cause this child.
Uh-huh.
Yeah, it's better off that way. We still don't know anything.
Well, not really. The state had all the witnesses. That's the problem.
Yeah, and there's a lot of witnesses.
There's the problem.
Yeah.
All rise, Collier County Circuit Court back in session.
Welcome back. Let's have Mr. Lyons return.
Your Honor, during the break, we have a resolution.
All right, Mr. Lyons, welcome back. And where do we stand now?
He is willing to admit both the condition 5 and condition 7 violations. In terms of the consideration of the resolution for an adjudication of guilt, which has previously been done, 48 months, Department of Corrections with credit for 87 days plus previous prison.
And restitution would go to a civil restitution lien order, or civil restitution lien, and I prepared the order, and Mr. Parker has.
That amount was previously determined.
It was a restitution.
And is there any reason to believe this plea agreement would be opposed by any alleged victim or otherwise?
I don't have a reason to believe that.
All right. And Mr. Lyons, do you believe this plea agreement and the certainty it brings is better for you than the plea to the bench or a full hearing?
Yes, I did, Mr. Manalich.
All right, very well. You've been previously sworn, remain under oath. And thank you, Mr. Lyons. And if we can go ahead and just do the plea call, you can be seated. Thank you, and we'll finish this.
So, Mr. Lyons, we previously started the plea call. Where we stopped was we were talking about the violations. As to the condition 7 and one of the condition 5 violations.
Yes, I plead guilty to both those.
Okay, so you're admitting that you violated those 2 conditions of your probation?
Yes, sir.
If you understand that by entering your admission today, you're waiving your right to a hearing on the violations.
Yes, sir.
And at that hearing, you would have had the right to see and hear the state's witnesses testify and have your lawyer question them.
Yes, sir.
You would have had the right to subpoena your own witnesses and submit evidence on your behalf. The right to testify in your own defense, and the right to make the state approve these allegations by a preponderance of the evidence. Do you understand that you're waiving those rights?
Yes, sir.
You also understand that if this case had gone forward to a hearing, the state could have also called you as a witness.
Yes, ma'am.
Counsel, have you heard anything about it?
We're not.
Mr. Lyons, do you understand that you're waiving your right to appeal anything other than whether this court has the jurisdiction to impose this sentence?
Yes, I'm just glad to get this one out.
And Mr. Lyons, I'm showing you an addition to a violation probation form. It's 1 page. Your name, your case number, and there are 2 signatures on the bottom. Are those your signatures?
Yes, sir.
Are those both, and have you, does one of those signatures indicate that you've read this form or that it's explained to you? Do you understand how the right to continue it?
Yes, sir.
Did you have a chance to review this form with your attorney?
Yes, sir.
And do you have any questions for your attorney?
No, I'm totally.
Okay, I'm also showing you your 4-page score sheet. Did you get a chance to go over this with your attorney? Okay, and your score sheet shows a total of 91.2 sentencing points. The maximum sentence you could receive is life in prison. Do you agree that this score sheet is accurate?
Yes, I do.
Other than what's contained in the admission form and what's been placed on the record, has anyone promised to make any addition to your submission today?
No, ma'am.
Are you entering this admission of your own free will?
I sure am.
Do you feel that entering this admission is in your best interest?
Yes, ma'am, it is.
Has anyone promised you anything or threatened or forced you to get you to enter this admission today?
No, ma'am.
Do you understand that while you may be entitled to gain time or time off of your sentence, there's no guarantee that you will receive such time?
Yes, ma'am.
Counsel, I'm sorry, Mr. Lyons, is there, have you had the opportunity to review everything about this case that you wanted the chance to review?
Yes, I'm ready to get this over with. I appreciate it.
Okay, and Counsel, have you reviewed all the violation probation discovery in this case with your client?
Yes, I am.
Do you understand, Mr. Lyons, that if you were not a United States citizen, you may be subject to deportation or removal as a result of this admission?
Yes, ma'am.
And that if you were deported or removed as a result of this admission, that it would not be a basis to withdraw your admission?
Yes, ma'am.
Do you also understand that if the offense to which you were admitting was sexually violent or sexually motivated, or if you had previously been convicted of such an offense, this admission may subject you to involuntary civil commitment as a sexually violent predator upon completion of your sentence? Do you understand that wording?
I kind of agree with that. I understand.
You were talking about,
Yeah.
so there's a statute that is out there, that you're a symptom of that. Your case is sexually motivated case does not connotate.
Okay, yes, I do. We talked about it, I just didn't know that. It does really I do understand that.
Okay, and counsel, do you stipulate the court may rely on the court filing the affidavits containing or in those factual basis and venue? and that they use proper fire time for it. Your Honor, at this time, the state would ask the court to take judicial notice of the court file, case number 17 CL 2296, a handed form, the plea form, the score sheet, the civil restitution lien order, as well as the order for Your Honor to determine whether the defendant is an injured proceeding.
So have the parties reached any agreement on the danger determination?
And the state takes no position.
All right. And Mr. Barger, any argument as to that?
No, Your Honor, and the argument is not being in the community, and he's not going to be forced operation after this. He'll be free and everything. Yeah, so I'm supposed to be.
The only question I would have for both sides is, I believe, well, first, as to the plea agreement, the court finds that the plea is freely, voluntarily, intelligently made with the advice of counsel, and that Mr. Lyons fully understood all of his choices here today, and that after twice conferring with counsel outside the presence of the court, he decided to enter this plea agreement, and you believe this is in your best interest. Is that correct, Mr. Lyons? And at this time, we'll accept the plea agreement. By agreement, it is an adjudication of violations as admitted. And on the underlying case, that was, Mr. Lyons was on supervision for burglary charge. Is that correct? That's the underlying case? And the parties are agreeing that that will now be 48 months Department of Corrections sentence, with credit for all prior prison time served, as well as 87 days in the county jail?
Yes, sir.
Yes, sir.
All right. Restitution, any previously ordered monetary amounts will be referred to the collections, but the restitution will be to a civil judgment.
Yes, sir.
There is a new $100 cost of prosecution. Any other new amounts? No other new amounts? Okay. And,
Just $100.
okay, that is ordered. Now, the only question on the danger issue is, one of the admitted violations is an injunction violation, Mr. Barger. What is the argument as to why that would not constitute a danger?
The violation of the injunction, the injunction was never even served on Mr. Lyons, and there was no probable cause found. When he was arrested on that charge, he was not ever told by anybody that the injunction was against his girlfriend. And he, once in the jail, called her to have her bond him out. And then at that point, he was told that he can't have contact with her. She's the one that the injunction is against. So it wasn't, none of this was willful and substantial. That's one of the reasons why we were going to fight that portion of it. And so she has later gone and said that she doesn't even want the injunction in place anymore and has taken steps to get that injunction lifted.
Now, Ms. Mason, was the injunction based on a attempted or actual contact by phone from the jail after arrest? Is that the basis?
That was the basis of the violations, Your Honor. My understanding is that the first one, that there was no probable cause found, and that was the 21 MM 453. No probable cause was found because at that time, although the hearing had taken place and the temporary injunction was put in place on March 15th, the defendant was not present at that hearing and it was not served on him at that time. However, my understanding, and I think it's a little bit different from Mr. Barger's, was that at the time that he was arrested for the violation of the one for which there was no PC, that he was told at that time that there was the injunction and that he still called his girlfriend from the jail. And that was the reason, my understanding is that's the reason why probable cause was found for that particular one. But as Mr. Barger indicated, the victim in that case has since had that temporary that injunction dismissed, and also contacted our office, our county court office, in 21 and then 455, and let the prosecutor in that case know that she did not want to go forward with that case, and that case was subsequently dismissed.
And the underlying burglary was not involving that injunction situation.
No, Your Honor, my understanding is that underlying burglary was a house that was under construction.
Right.
The defendant broke in
Okay.
and took a stolen.
Based on what has been described, the court will find that Mr. Lyons is not a danger to the community based on the violations. And the plea agreement is approved as stated. Thank you for resolving your case.
Thank you, Mr. Manalich. I really appreciate it. I want to really thank you. You really changed my life.
Very good. Well, good luck.
And
Just
I can't wait to get this beyond.
do well in the future.
Mr. Manalich.
I'll go ahead and fill out the order now, Madam Clerk. And I believe that we are now adjourned.
That's a wrap.
Okay.